I go first, right, Dave?
We're going to begin in just a moment here. If I can ask you all to please turn off your cell phones, leave them on silent, turning off is preferable. Any tablets, iPads, anything else that might make noise. That can be quiet. All rise. The Court of Appeals, Division 1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in the matter of Silver Springs Oasis LLC et al. Versus Lawyer Title of Arizona, Inc., our civil number 12-0860. Each side will have 20 minutes within which to present its argument here this morning. Appellant may reserve some portion of that for rebuttal. However, it's incumbent on you to keep track of your time in that regard. We have read the briefs. We're familiar with the record. So we understand, we think, the issues being presented here this morning. So please take that in mind as you make your arguments. We are recording the proceedings, both audio and video, and at the appropriate time you can access the video by going on our website in case you or your clients wish to view the oral argument. But as you approach the podium, please identify yourself and your client for us. With that, appellant may proceed.
Good morning.
Good morning.
My name is Greg McGill. I'm the attorney for the appellants Silver Springs Oasis and Dale Argerbaugh. And justices, if you'll allow me to introduce my client, who is the current manager of Silver Springs Oasis, Your Honors, which is Dale Argerbaugh. He's sitting to my left. And I do expect to go about 15 minutes, and I'll try to reserve about 5 minutes, justices, if I may. Thank you. As Justice Winthrop indicated, the court has read the briefs, is familiar with the materials.
You're giving us a little too much title here. We're just judges. The justices are upstairs on the Supreme Court.
Thank you, Your Honor. I understand. Thank you.
Thank you.
Absolutely. The issues in the case are, as the appellants see it, are essentially four issues for the court to reflect upon this morning. The first, which is the core issue, is did lawyer's title, which at the time you'll see on the documents was TransNation Land America. It was purchased and acquired since then by Fidelity Insurance Group, hence lawyer's title is in the action. Did the title company have a duty to act upon an express supplemental escrow instruction that was documented in the escrow transaction, which involved Silver Springs Oasis? Did it have a duty of diligence, a duty of disclosure, and a duty to seek clarification based on the information that it had available in the escrow file? That's the core question. Now, the appellants, our position is that that duty is broad within the context of the appellate decisions that have been rendered in this state. But it was broadened by the Maxfield versus Martin case beyond the Burkons case, the Burkons versus Tycor title, which I'm sure this panel is well aware of.
Doesn't the case law suggest that any duty that the escrow company owes is owed to the parties to the subject transaction, not to those who may be remotely or even less remotely interested in the transaction?
The law does speak to that the duty is owed to parties in the transaction, but I would, but the interpretation based on the Maxfield versus Martin case and the Burkons versus Tycor title case, the interpretation of the parties to the transaction is broader than what the title company will posit to you in a few minutes. And that is, whether you're a party to a transaction, that definition, Your Honor, is broad in the sense that the real question becomes, do any of the documents in the escrow suggest that you have an interest in that transaction? If the answer is yes, then you're a party to that transaction.
Mr. McGill, I don't see anything in Maxfield or Burkons that stands for that proposition. Maxfield was a party. She was an involuntary party because she didn't know that she was being listed as the borrower. But our court said that because the escrow was, quote, intended to include Maxfield as a party, she was entitled to the protection of fiduciary duties. So I don't see how Maxfield helps you at all.
Well, Maxfield helps, Your Honor, with all due respect. The Maxfield helps because in that case, as I understand it, Maxfield was not a voluntary party to that transaction.
She was a party. She was listed as the borrower. So obviously the title company looking at the parties to the escrow, Maxfield is listed. So Maxfield to me stands for the unremarkable proposition that she didn't know she was a party, but because the title company should have known the borrower listed as Maxfield was a party, it owed her duties.
Right, and that's exactly correct. Let me answer it this way. There's two components to my response to your question. One is, in the Maxfield case, as I understand it, she was made a party through a fraud, through a forgery, through a forged identity. But you're correct that the title company thought or believed that she was a party because her name was in the escrow. That's true, and I think that's what you just said. Going from that proposition, the question becomes, did lawyer's title have any reason to believe that Silver Springs had an interest in this escrow. That's the question.
But no case says that. No case says that because somebody might have an interest in the escrow, there are fiduciary duties owed by the title company.
Well, Maxfield, I think, Maxfield says that if a party, even if they're an involuntary party, Maxfield, as I read the case, says even if they're involuntary, because they were, it was a fraud that put her there, that even if it's involuntary, if she had an interest in that escrow, the title company duty was created as a result of that.
I think you're conflating the issue of duty, a legal question, with the question of the scope of the duty, because Maxfield says because she was a party, a duty was owed, then it explains the scope of the duty, which is what you're seizing on, but that doesn't address the threshold legal issue of was a duty owed in the first instance.
Let me go to two new points, Your Honor. Let me just move to two new points that address your concern. The first is, it would be anomalous for this court to hold that we have a fraud claim in this case and that they removed Silver Springs from the escrow, removed them from the escrow. That's part of our fraud.
Correction.
Well, not to be removed from the escrow, but what happened was, just a very brief background to put this in context. This was supposed to originally be a double escrow. It's the title company said, no, we can't double escrow, where Silver Springs would purchase from Tonopah Land Development and then turn around and sell to a second buyer in a double escrow. The title company came in and said, we can't do that for insurance purposes. We can't share the transaction as a double escrow. So the title company was the genesis behind changing that. They restructured it through the title company's impetus and then set it up as a nomination where Silver Springs would nominate the ultimate buyer, which was Moore, into the escrow, and then the title company, and this is part of our fraud claim. I would agree with you, Your Honor, if it was a simple contract transaction, but they committed a fraud to remove us from this escrow. That's the important point. Once they went from the double escrow, title company says, no, can't do it, can't insure it, then they go to a nomination and then pull us out of the escrow. Now, that's why they have a duty, because they know we're involved, and when you pull us out of the escrow, knowing we're to have an involvement and to receive $3.7 million, that's a question of fact that should be going to a jury on our tort claim. Let me go to the second point on the duty, just strictly on the legal part of the duty. I'd like to come back to that if I may. In the Burkons versus Tycourt title, and this is in my supplement, and I quote, and I believe this was the Arizona Supreme Court, the justices upstairs, Your Honor. Quote, we believe the true principle is that the escrow agent must be cognizant not only of the escrow instructions, but of the provisions contained in the documents that are deposited in escrow. The title companies want you to rule that their duty is narrowly circumscribed by the escrow instructions, and my position is if you go to the supplemental escrow instructions, they had a duty because we're listed in the supplemental escrow instructions, it's Exhibit 2 to my appendix, where they're supposed to record us in the third lien position. If they add up the liens, it's $10 million, it's not 6.3.
But
So
the part of Burkons you just read is preceded by the notion that they can't rely only on the escrow instructions and have to look at agreements between the parties to the transaction. And again, your client wasn't a party at the time of the alleged misconduct.
Well, see, that's what we're arguing. We were a party at the time of the conduct because Samir Gaddis was the manager at the time, and he was at the escrow, and I provided, if you go to the exhibit, I provided in the appendix, I believe it's exhibit 9, in the appendix. I provided the handwritten notes between the escrow agent, Tara Dominguez, and Jody Moore, the ultimate buyer, where they're going back and forth talking about a conspiracy and removing us from the escrow. So again, I go back to the tort. I'm sorry, Your Honor. Again, I go back to that tort claim, the fraud claim.
What's the causation that links the alleged tort to your client's loss? What's the theory by which?
Gaddis is at the escrow. It's a $10 million deal. Tonopah Land Development, Montserrat's the seller at 6.3. My client comes in and purchases. It has a contract position. It turns around at that time, a lot of contract positions were sold. So it sold its contract position. It wanted to double escrow that position at $3.7 million. Title company said no. Goddess said, okay, we'll do this nomination. So they nominated the Moores, but that didn't mean that they were withdrawing from the transaction. Your Honors, what would support the $3.7 million note unless it's part of the escrow and part of the transaction? What would support it? It would be meaningless.
Well, is your client's damage the fact that the Moores didn't pay the note?
No, the damage is removing it when they removed Silver Springs from the escrow and reduced the price from $10 million to 6.3. The price, the consideration for this transaction was always $10 million, not the 6.3. When they removed us from the escrow, the damage was our note was impaired because the note was inextricably linked to the escrow. If we're not in the escrow, the note, even though facially it's a note, I agree it's a note, it says it's an IOU, but what happened in 2008, which told the limitations period, but in 2008, Moores, the buyers, filed a lawsuit. They were the plaintiff. That told the case, and their argument in their suit was that the note has no consideration because you weren't part of the escrow, it's meaningless.
But that case was dismissed.
The case was not dismissed on the merits. Judge Oberbill.
Dismissed, so what's
That's
the
true.
damage? What's the damage that your client incurred?
If we were part of the escrow, if the damage.
Meaning if your client was the buyer.
No,
right?
no. If
Okay.
we were part of the escrow without getting pulled out of the escrow, we would have been part of the 10 million, and we would have had a position to recover here. We would have had a position to stop the escrow and redo the transaction and
Cover from what? From whom? The Moores?
well, yes, from the Moores, because the Moores turned around in 2008. They turned around and sued and said, you're not, they committed the fraud with Terra Dominguez, pulled us out of the escrow, and then tried to benefit from their self-dealing, filed a lawsuit in 2008 and said, your note is worthless, you're not part of the escrow. What supports the note? And we couldn't answer that. That's the predicament we're in. That's fraud.
But that suit's gone, so has
No,
Silver Springs...
that suit was dismissed because the Judge Oberbillig told them they had to post a $125,000 cost bond.
So it's gone.
He dismissed it without prejudice, but it told the limitations period while it was in for a year and a half because the lawsuit tolls the clock. And then we filed in 2008 because they didn't pay on the note. Their defense to the note was the same as the theory in their lawsuit. No consideration. This note is worthless. You're not part of the escrow.
That's the heart of it. Your client sued the Moores unsuccessfully? Is that what you're saying?
We sued the Moores and we sued the title company.
Okay, and the
Right.
Moores defended, saying there's no
They
consideration.
defended, we settled with the Moores. We're
Oh, you
here
settled
with
with
the
the
title
Moores.
company. That's correct, Your Honor. And I'll reserve 5 minutes if I may. If that, I'll stop. Right? If I may.
Counsel?
Good morning, Your Honors. David Los Baluto for the defendant lawyer's title. We argue that summary judgment should be affirmed. We think that it's a fundamental rule of summary judgment that the opposing party can't just give blanket denials and rest on allegations and point generally at evidence and then conclude that an issue of fact exists somewhere in the record. But we see that that's exactly what the plaintiffs had done in this case and exactly why summary judgment was granted and should then be affirmed. When we look at the issues, we'll see that the trial court was correct in saying that he shouldn't have had to hunt for truffles in the record, so to speak, that the response to the summary judgment was simply insufficient, both on the facts and the law. Now, we also have a fundamental rule that a party can't raise new issues on appeal that it had not raised down below. We see a number of issues, as we pointed out in our brief, that have been raised. An appeal is not a do-over. It's the opportunity to expand or expound upon what you've argued previously. Plaintiffs are trying to raise a lot of new issues here, and that's another reason summary judgment should be affirmed. So we basically end up having two areas here of discussion. We have the waiver, and then we have the merits of the arguments themselves. And we think on both grounds that summary judgment should be affirmed. I'd start briefly just by referencing the waiver and what plaintiffs did waive. Plaintiffs' response to lawyers' titles summary judgment motion had an argument that was less than a page, excluding the summary judgment standards. It basically was about 4 sentences long. We had one paragraph, which was 2 sentences on the duty issue, 1 sentence on the statute of limitations, and then 1 sentence on damages, and then we had 1 sentence that just said that the fraud claims, the tort claims are supported, and then citing 2 restatement sections. So our response or reply to that, of course, was appropriately that they had not responded to a number of the issues that we had raised on summary judgment, and even those that they had addressed, they had not addressed adequately. And then the response to the defendant's statement of facts, plaintiff admits most of the 26 facts and just blanket denies, I think 9 or 10 of them, and just says they're either false or wholly out of context. And under Rule 56C, these sort of blanket denials are insufficient, and so therefore plaintiffs would have been deemed to have admitted all of defendant's statement of facts. Now, in the responsive statement of facts, plaintiff set forth just 3 quote-unquote facts, which were really more legal conclusions that were insufficient to have an opposition to a summary judgment motion. One was the conclusion that the claims had accrued in June 2006, and then citing a number of exhibits. The number 2, that the contract and note and recording the deed of trust were, quote, part of the escrow, and then again citing a number of exhibits, and then, quote, there was substantial evidence of damage in the record, and then again citing a number of exhibits, without saying more about those exhibits or what the court should have been drawing from those exhibits. So the summary judgment rules are designed to make the parties come forth with their arguments and with their specific facts and evidence, and we simply don't have that here. And so faced with this, the trial court correctly granted summary judgment. And then when we get to the merits of the issues themselves, we still think that summary judgment would be affirmed regardless of what the plaintiffs said. Now, plaintiff has addressed the duty issue here, so I'd like to start with that issue. As the court's pointed out, the duty is an issue of law for the court. Escrow company duties are to those with whom it has a contractual relationship, and the contract sets the scope of the duty, and there are good reasons for that. The escrow company has to know who it owes duties to, not simply anyone with an interest in this escrow, with an interest in the transaction, or somebody that there's some sort of involvement during the course of the escrow, because the escrow company is in contact with any number of lenders and whatnot. Those are not parties to the escrow. The escrow company has very specific duties to those who it has entered into a contract with its principals. And if it suddenly broadens to include anybody that has any sort of contact or is mentioned anywhere during the escrow, you suddenly have the escrow company with potentially conflicting duties. Who does it owe a duty of confidentiality to? Who does it owe a duty of, a fiduciary sort of duty to?
Well, counsel, let me ask you this. Mr. McGill, I think, acknowledges the general rule that you've just reminded us of, but says that in this case, your client actually played an active role in shaping who the parties were going to be to the subject transaction, and therefore, in his view, elevates Silver Springs to something more than an entity that was merely identified in the attached documents as having some interest.
Well, first of all, Your Honor, I don't see any cases that allow a party that has contracted out or substituted out as a party to an escrow to be able to enforce some sort of escrow duties. Now, one issue also is that the escrow amendment, is not including them as a party. And SSO itself sought that. We have Defendant Statement of Fact 20, which asserts that. We don't have a proper opposition to that.
Interrupt you on that because
Yes.
I think it's an important point. It's your position, I think, that the nominee instruction, which is dated June 15th, signed by Silver Springs and the Moores, and then the supplemental escrow instructions dated July 6th are the first is the document that triggered the supplemental escrow instructions, and in your view, removed Silver Springs as a party to the transaction and substituted the Moores in their place. That's your position, correct?
That's correct, Your Honor.
Prior to that time, I think there would be no dispute that Silver Springs was a party because it had the purchase agreement and escrow instructions with Tonopah. You would concede that prior to the nominee instruction and supplemental escrow instructions, Silver Springs was a party to the escrow.
I would agree with that, Your Honor. And so basically what we have is them substituting out as escrow and choosing to substitute out as to the escrow, and lawyer's title saying we're not going to have you as a party to the escrow, basically not saying we're not going to do this double escrow. And there are good reasons for not wanting to do that and for us not being able to cover that sort of a thing because of this potential for conflicting duties, because when you have these multiple party type escrows, if they had wanted to do perhaps a separate escrow entirely and have themselves as buyer to that transaction, they could have had a separate escrow. They chose not to do that. They could have chosen to do that. So ultimately, the only parties to the escrow are the seller and the Moores, and those are the parties to the escrow transaction. Now, in opposition to our summary judgment, of course, as I mentioned, there were only two sentences in opposing summary judgment, that it was clearly part of the escrow and that it didn't need to be a party because it had an interest based on the contract documents and lawyer's title recording the deed of trust, and then, of course, a citation to Maxfield. And I think Maxfield doesn't expand the duty beyond the parties to the escrow. In that case, Ms. Maxfield was actually listed as a party to the escrow, and the title company there, of course, believed it had an escrow duty and contract with Ms. Maxfield. It simply had the wrong Ms. Maxfield. It has an imposter, and it hasn't confirmed as to what her role is. And we look at cases like Perkins and Berry that specifically say that the contractual relationship existed, and therefore the duty to those contracting parties existed. The Luce case, I think, also, which we've cited in our answering brief, is directly on point on this issue as well, as far as who the parties are to the escrow. There they had the partnership itself getting a loan on property in violation of its partnership agreement. The limited partners then saying, look, we had an interest in this property. The partnership agreement was actually part of the escrow. Shouldn't we also be parties? And the court, citing Perkins and Berry, said specifically no, that the scope of the duty is limited specifically by the terms of that contract. It's not simply a matter of who has contacts, who has interest. It's not just if you're mentioned in an instruction. There's a reason that they're mentioned in the instruction, and that's because the principals to the contract, the seller and the buyers, the Moores, put that in there, and that was their election. And at those principals bidding, the lawyer's title then recorded in the third position, as SSO was aware, the deed of trust. So the mere fact that you have a deed of trust involved somehow doesn't make you a party for all duty escrow purposes. And so I'd like to move on, if I may, unless there are further questions on that, to the damages issue that was raised, the causation damages issue. We think the court was correct down below in not in granting summary judgment that there was no causation with respect to the damages at issue in this case. SSO, as it states here, had a claim for damages that it was having difficulty collecting on a perfectly valid promissory note. Lawyer's title did not do anything to invalidate this note, regardless of whether the note was included on the HUD. SSO still has the same rights to collect on the note. It was a secured note at the time. It had its security interest properly recorded by lawyer's title. There's never been some adjudication that this promissory note is somehow unenforceable. So they still have this perfectly valid note, and nothing lawyer's title does.
Well, it was either valid or invalid, but your position is the lawyer's title didn't do anything with it.
That's right, Your Honor.
Void to begin with, it was going to be void.
Right. And so including it in the escrow doesn't grant it consideration. There was, the counter argument, of course, was, well, yes, there was consideration. We assigned, SSO assigned the position, and so that's going to be their counter argument to say, look, we have consideration for this note, and lawyer's title didn't have anything to do with whether there was consideration as to that note. Now, plaintiff's response on summary judgment was simply to confirm that this theory that it was difficulty collecting, and then to sweepingly say the exhibits and testimony of Grabois established substantial direct injury, and then citing to 8 different exhibits, which really doesn't raise an issue of fact. Even now, the opening brief doesn't address this issue. The supplemental brief doesn't address it. There is an address in the reply that simply says, well, it was for the jury to decide. But really on the facts of the case and on the undisputed facts of the case and on SSO's failure to raise any facts on it, it really was a legal issue for the court below to decide. It's also worth noting, as in our reply summary judgment, that RESPA really only applies. It's kind of a RESPA theory. It's on what goes on the HUD and the buyer and seller and what gets disclosed in the HUD, and so they're neither buyer nor seller, and the RESPA really doesn't provide a private cause of action for the disclosure at the loan closing on the HUD. And so
in any event, how would it have made a difference?
That was our argument, yes, Your Honor. That's what we were saying down below. So now we also did touch on the statute of limitations briefly during plaintiff's argument. Plaintiffs did
Interrupt you, Mr. Dispaluto. I'm sorry, I botched your name.
That's okay. That happens.
Dispaluto. There were 3 issues identified in the opening brief. Was there a duty, disbursement of the commission, and attorney's fees? The rules require you to set forth the issues on appeal, and those are the issues on appeal, in my view. Do you want to, I don't know if others are interested in the statute of limitations, but that has not been identified as an issue on appeal.
Yeah, and that was an issue that I think that was properly granted down below. We raised it, obviously, as a summary judgment ground. It really wasn't opposed down below, except for the accrual point and a tolling potentially. And so we think that this court can affirm based on that. Now, the court's opinion down below specifically said that the plaintiff hadn't indicated how the statute of limitations was told for each cause of action, and that was actually true. And we still don't have an explanation as to how this other lawsuit was supposed to toll these statutes of limitations. And so I think that's another ground on which now the court down below could only really have reached that conclusion if it had already concluded that the statute of limitations had expired, and there really was no opposition to the fact that SSO and their principal knew as of the closing their entire damage theory, their entire fraud theory was that it had not been listed on the HUD, but supposedly it had been promised that the note and the $10 million amount would be listed there. And they knew that as of that point, and therefore it had accrued. There's not really an explanation of why it would have not accrued until the June of 2008 time period. So just to briefly address that one, Your Honor, that's what we say on that. The commission issue, we have a sentence, it is true, raised in the opening brief on that. And so if I could address that, the allegation.
Clarify something procedurally on that point, because the only argument in the opening brief on the commission is that it was illegal under ARS 322155, and I didn't see that argument anywhere made in the Superior Court.
That's right. I think it was just that it was an illegal commission. I think it was generally. I don't think there was any statute cited, or that it was that it shouldn't have
gone. In the Superior
gone.
Court, the only statement about the commission in opposing summary judgment was that any claim was told by the 2008.
That's right.
lawsuit.
That's
There was
right.
nothing claiming it was illegal. So is that anything we should entertain on appeal?
That is, Your Honor. I think the commission issue was waived on summary judgment. The response to the summary judgment, I think, did not actually address it. We addressed the standing issue. We raised the standing issue. We raised the statute of limitations issue. We raised that it really was subject of a creature of statute under ARS 322152. Those were not addressed at all in any way in the response to the summary judgment. Even considering this appeal, we still don't have anything addressing what sort of standing plaintiffs have to enforce somebody else's commission that they allegedly were promised. Really, it's Southwest Realty, the realty company, or potentially the real estate commissioner, I suppose, who would be able to enforce allegations of violations under the real estate code. And this 32-2155 that plaintiff says it's clearly illegal under, that still doesn't grant them any standing. In the reply brief, there's a mention that 21, I think it's 2152. I may have said 31, but I meant 32-2152 allows any broker to sue for commission. That doesn't mean any broker can sue for any other broker's commission. That simply means that the broker can sue for his or her own commission or its own commission. And then we still don't have anything addressing the statute of limitations. It's a 1-year statute of limitations. This is well beyond that. We don't have any indication as to why that should have been accrued later or told later. Obviously, plaintiffs knew about the commission, back at the time of the transaction, and so we don't have any indication, on why that would have been told. And so I think this court can affirm on all of those grounds. I think it's also worth addressing the fraud and negligent misrepresentation theory that the court was clear on granting on, that they had not raised any allegations of representations as to present facts or present matters.
Can I interrupt you again? Because
Yes.
those are not challenged in the opening brief. Those are nowhere identified as issues for appeal. I'm more interested in those counts as it relates to the fee award and whether fees were properly awarded on those counts.
All right. So, okay. I argue that those obviously were waived, and so I don't know that I need to address the merits. As to the fee award, Your Honor, I'd like to address that briefly because that is challenged on appeal as well. I think it's a clear rule under the fee statute that a duty created by contract is one that allows fees. The fees are also allowed for establishing the absence of a contractual relationship. Here, the escrow agreement. Here, the allegation was that them being a part of the escrow, which is all a subject, a creature of contract, gave rise to these sorts of fiduciary duties that give rise to the fiduciary duty claim, that give rise to the fraud claim and the negligent misrepresentation claim.
Well, I understand that as to the breach of fiduciary duty claim. Walk me through why the fraud and negligent misrepresentation counts also fall within the purview of a fee award.
Yes, Your Honor, because in the escrow, the duty in terms of making representations to the plaintiffs, those all allegedly arise out of the concept that we owe them a duty under the escrow to disclose substantial evidence of fraud during the course of the escrow. And so, any duties that we have to make representations about what's going to happen during the escrow itself has to arise out of our duties. Without that, there's no duty to them as a bystander to the transaction to know what's going on the HUD and where the real estate commission is going and what the total sales price allegedly is. And so plaintiffs' theories all related or stemmed from duties that don't exist unless there's a contractual relationship with the parties.
It's an interwoven tort claim in the language of the Ramsey case and some of the others that talk about fee awards under 12-34101 on tort claims, that the tort claim is interwoven inextricably basically with the contract claim.
I think it is interwoven inextricably, and I think it's simply the duty under these other theories doesn't exist absent the contract claim. So I think it's interwoven, but I think it's a little bit more than that because of the existence of the duty, the particular nature of the escrow duty to disclose quote unquote substantial evidence of fraud under Birkins. Arising because of the contract relationship and the escrow contract, I should say, so therefore a contract relationship. So that's what we would argue on those. And unless there's further, I am out of time. I ask that the court affirm. Thank you.
Mr. McGill.
Thank you, Your Honor. I'll just go through it as quickly as I can. The first point I wanted to make is that it is painfully obvious to our side that in this transaction, it's a $10 million transaction, and it was documented as a $10 million transaction. The way the title company is presenting this to you is that, no, it was a $6.3 million transaction. They misreported the transaction. The transaction became over-encumbered with liens totaling $10 million. They knew we had a lien. They agreed to record it. They agreed to record our lien as part of this transaction. It's in the supplemental escrow instructions. We have to ignore the document to act like it doesn't exist. It's real. It's in the papers. It's $10 million. The way they did the transaction, they're supposed to do this transaction with scrupulous honesty, integrity, skill, and good faith and disclosure. Did they have a copy of our lien? Yes. Did they agree to record it as part of this transaction? Yes.
What didn't Lawyers Title do?
Okay, so what they didn't do, there's two things. What did they do and what didn't they do? What they did do is what Judge Winthrop just indicated, which is our position, is that they engaged Jody Moore and Tara Dominguez. I gave you the notes. They have notes talking about a conspiracy, pulling us out of the escrow, hiding that fact, not disclosing that to us. This is an escrow agent, not disclosing those communications to us. We didn't know we got pulled out of the escrow. We think we're still part of a $10 million deal. And that's what they did do affirmatively. And what they didn't do is they didn't tell us that they were doing that. They had the secret communications going on, pulling us out of the escrow. We don't know that. Your question, Your Honor, Ms. Johnson, is a good one. You said, how does it matter? How does it matter? You still have a note. I think that was the thrust of your question. Here's how it matters, Your Honor, and it's very nuanced. If I have a note, but it's not supported by anything other than just words on a page, it was supposed to be, and it's a large note, $3.7 million. It's not a note for 10 grand, $3.7 million. The psychology of investing, borrowing, the borrower's psychology, willingness to pay it, believing it's owed, believing there's consideration, not getting in a lawsuit over that. Is our note impaired if the borrower's psychology thinks the psychology that nothing supports the note? This was a land transaction that supported the note. When they pulled us out of the escrow, we're left with a piece of paper. It's worthless. And the party who's self-dealing, communicating with the escrow agent, with the notes, the smoking gun notes I gave you in the record, pulled us out of the note, self-deals, sued us in 08 and said, we don't owe the note. She sued us. We don't owe the note. There's no consideration. You're not part of the escrow. So she tried to benefit from her self-dealing. Let me go to the last 2 points. The fees. The tort claims are independent of the contract claim. I cited the Bennett versus Baxter Group Inc. case. I was the attorney on that case. It's a published decision from this court. In the Bennett versus Baxter case, the appellate court said very clearly, there's a duty not to commit a fraud, which is a legal duty separate and apart from a contract. So this notion that's being posited to you, that if you just got a smattering of tort claims and you happen to have a contract claim in there, and the contract claim is really not the core claim, the core claims, which I've been saying this morning, is the tort claim, the fraud claim, that's not time barred under any scenario, because it's 3 years. And I explained that in my brief. That's a tort action. The gravamen is tort. Duty not to commit a fraud is not dependent on a contract. And it's not inextricably tied to the contract. So you don't, by just slipping in a contract claim, you don't get fees for everything later. That's not the law. And the panel knows that. The last point is this. This property, if this court affirms, we're just asking for a trial. We claimed below that there were triable issues of fact on this tort claim, on the fraud claim, and what they did and whether they were actively involved in removing us from the escrow, self-dealing, and profiting from it. They pulled it off. The title company did the title company when it agreed in a supplemental escrow instruction to record our third lien. When you add the liens, it's $10 million, and then they report it on a HUD at $6.3 million. The state has an interest in knowing what the total consideration in the transaction is from a tax standpoint. We have an interest because we're part of it. And if we get pulled out of the escrow with a note of this magnitude, no one will pay it. And she didn't and sued on that very ground. That's her point. So if we were in the escrow and the title company came to us and said, wait a minute, we're agreeing to record your lien. The liens are $10 million in this transaction, but the sale price is $6.3. Tight court, is the way I understand it is, they should have come to us, stopped the transaction, and said, Is this a $10 million deal or a $6.3 million deal? That seems very elementary to me. That didn't happen. Had they done that, we could have come in, restructured it, protected our interest, got Jody Moore to sign an acknowledgement that there is consideration for this note, that it is part of the transaction, and we would have had a different ballgame going forward. But based on the self-dealing and the fraud, we got injured, and the title company is saying, essentially, we don't owe you a duty. But the documents belie that. Thank you,
Thank
panel.
you, counsel.
Thank you.
Thank you. Appreciate the arguments presented this morning by both sides. We will take this matter under advisement and issue a written decision in due course. That we are adjourned. Thank you.